Today, we are very, very fortunate to have a research seminar that brings some multidisciplinary components that work with finance, traversing areas in competition law, political coalitions, and varieties of capitalism. And the paper today is a joint paper by Dr. Chase Foster, one of our own here at SOAS, University of London, and Professor Sebastian Kohl, who is Professor of Sociology at the Free University of Berlin in Germany. Now, I know our colleagues here have met Chase, but I think since this is a global research seminar, let me have the pleasure of formally introducing Chase. So Chase is a lecturer here in public policy and management here at SOAS University of London. He joined us almost about a year ago, and very prolific. Is contributing in a number of areas in management and finance. Based on his background, rich background, he received his master's in public policy and his PhD degrees from Harvard University in the US. And also he has a degree in public policy and African studies from the University of North Carolina in the US. He has had the pleasure of working across different academic environments across the globe. Previously, he held academic posts at the Munich School of Public Policy, also at Brown University in the US, and also closer here to SOAS at the London School of Economics and Political Science. His expertise traverses quite a number of interesting areas where he's drawing from for this seminar today. Has expertise in comparative political economy, of market regulation in particular. And his work has been published in leading international journals, including Socio-Economic Review, European Union Politics, Regulation and Governance. He has an interesting manuscript of a current book on trust on trial. Absolutely interesting. Competition law, coordination rights, and varieties of capitalism, in which he is examining the durable ways that competition law and public policy can shape the development of capitalism during the contemporary period. It's also interesting to know that Chase has extensive experience working as a policy practitioner in international context, but also in domestic context, especially, again, in the active participation in the areas of contemporary public policy debates. His co-author, Professor Sebastian Kohl, is a professor of sociology at Free University of Berlin, the JFK Institute, and previously was a senior researcher at Cologne's Max Planck Institute for the Study of Societies, very well-known institution, where he received his PhD and co-tutor with Sciences Law, a leading institution. Professor Kohl has also been a Kennedy Fellow at the Center for European Studies at Harvard and worked at the Sociology Department of the Institute for Housing and Urban Research in Uppsala, and a prolific researcher with the top-tier publications in Socio-Economic Review, Review of International Political Economy, Politics and Society, and the American Economic Review, as well as the British Journal of Sociology. So there is a big common element between what Sebastian researches and, of course, what Chase researches, including their joint work in this particular paper. So I would like to ask you to please put your hands together and give a hand of applause of welcome to Chase to share with us his exciting ongoing work. He had explained to me that this is ongoing work. In the usual tradition of the Center for Global Finance, we should be able to make comments, constructive suggestions, and engagement with this research, which is in the process of being developed. Chase, you're most welcome.
Okay.
And you have the floor.
Great. Thank you, Victor, for that really nice introduction. Hold on one second. Okay, can you see my screen, everyone?
Yes, okay. We can see, but just you can now change. Yes, exactly. Share.
Okay,
excellent.
So this is actually sort of the quantitative test of the book project I'm working on that looks at the development of competition law since the 19th century and its interaction with the development of capitalism, right, in different ways across mostly Europe and North America. But my hope is that by the end of the presentation, you'll possibly also be convinced that this kind of framework of thinking about the relationship between competition law and the organization of capitalism is more generalizable, and we could even use it to better understand the development and operation of markets outside of the regions that we're focused on here, perhaps also to developing and emerging market economies as well. So because I know that we all come from different disciplinary backgrounds and traditions, I'm going to spend a little bit more time than I normally would kind of going over some of the foundational theory that Sebastian and I are working in and responding to. And so we'll start kind of with the main theoretical motivation, which is the question of how does competition law, and really the law more generally, shape the organization of capitalism? Now, when we turn to some of the most important economic histories of the development of industrial capitalism in the United States, including these books by Naomi Lamoureux and Martin Sklar, as well as Alfred Chandler's foundational work, it's quite clear that antitrust law was quite important in the development of corporate capitalism in the US, right? In particular, the early antitrust systems, which were not only enacted in 1890, but even preceded that through various common law rulings, they made it quite difficult for firms to create horizontal agreements to stabilize market volatility, right, through business associations or cartels or other kinds of systems. This was desired by basically all business beginning in the 1870s, given the boom and bust cycles and a significant turmoil that was caused by depression and recessions every couple of years. So all business wanted to do this, but in the US, it became very difficult to not only create the agreements, but to enforce them. And then with the enactment of antitrust laws in 1890, a lot of horizontal options for stabilization were cut off. And so firms began to pursue mergers and acquisitions, right? This became the way that the market was stabilized. And so from 1895 to 1904 in the US, which is what Naomi Lamoureux looks at, we see an incredible degree of consolidation in the US business environment. And this created a distinct model of capitalism that really was different from anything we see in Europe at the time, as well as Japan as it industrializes. In these other systems, firms were generally able to stabilize the market through some kind of horizontal agreement to differing degrees. So some countries, permitted cartels but didn't allow their agreements to be fully enforced. But other countries, such as Germany, actually explicitly legalized them, right? So we start to see German court rulings, private law rulings, beginning in 1890 that basically say that price agreements, output restrictions, specialization agreements, these things are all part of self-help on a cooperative basis. In fact, the dominant economic paradigm of the period, the German historical school, actually saw cartels as an organic outgrowth that was necessary for the development of industrial capitalism to kind of allow the kind of stability necessary for long-term investment. And by 1897, cartels were explicitly legal. And as Kathy Thielen and others have pointed out in research on this period, the allowance of horizontal coordination by firms also facilitated the development of non-market coordination by workers, right? Because it was easier to get firms to agree to labor agreements if they themselves could agree with their competitors to kind of cooperate on this issue. Whereas in the US, actually, antitrust wound up being quite important for undermining labor. In fact, about 1/3 of all antitrust lawsuits were enacted against labor unions and attempts by workers to form associations. In some cases, companies even sued their workers for damages when they went on strike using the Sherman Act. And so basically, we know from this historical research that there really was an important role played by competition law in creating distinct models of capitalism. In Germany, in particular, we see the development of a quite coordinated system by the 1920s, in part because of their permissive approach to antitrust. And so sort of, we know that this was important historically. And the dominant paradigm, at least until recently, in comparative political economy, which is the tradition I work within, was varieties of capitalism. And of course, in this framework, Germany and the US are the two different ideal types, right? We have the US, which is seen as closest to the liberal market economy ideal type. And we have Germany, which is viewed as closest to the coordinated market economy ideal type. And what's interesting is that the main distinction between these two ideal types is the different modes of coordination that are used by the most important firms in each economy. So in LMEs, coordination is mostly through corporate hierarchy, going back to the great merger movement I mentioned earlier, as well as arm's length relationships with competitors, right? So it's two forms of coordination. You can do hierarchy within the firm, but beyond the boundaries of the firm, with basically all other contractors, workers, relationships, it's arm's length. Whereas in the coordinated market economy ideal type, of course, there are corporate hierarchies and there is some arm's length competition, but coordination also occurs through non-market modes, especially in areas such as standard setting, technology diffusion, research and development agreements, specialization in particular product areas. Firms will say, I'll specialize on developing this kind of bolt, you specialize in developing that kind of bolt, we'll agree to not go into each other's area. That is sort of been very much at the center of German industrial development. And even today, we still see strong signs of this coordination. So we know that there are these differences. We know that there were these historical differences in competition law, and yet no one really has examined systematically over the long term whether or not competition law is related to objective measures of non-market coordination, things like labor union density, employer union density, trade association numbers, the prominence of vocational training programs, non-market finance, et cetera. So that's really the aim of this paper. It's to kind of provide a big picture overview of the long-term relationship. We're not really looking at causal explanations here, in part because the theory itself is based on complementarity. So the idea is that actually everything's endogenous, that sort of the things co-evolve together. But we nevertheless think it's quite interesting to see if there is, in fact, an empirical regularity that we can point to that would be consistent with the theory. So just to kind of go back to the V of C theory quickly here. So I already mentioned that there are different coordination mechanisms, but the theory also specifies that there are 4 distinct arenas in which we see these distinct modes of coordination. So the first is corporate governance. So in LMEs, we see dispersed shareholders, more of this arm's length relationship in terms of ownership, whereas in CMEs, there's a heavier reliance historically on concentrated ownership by banks or by family firms or foundations, et cetera. We see different kinds of financial structures, more capital markets, of course, in LMEs, more a greater prominence of domestic bank lending, including with some cooperative banks and state-owned banks. In the CMEs, we see different modes of labor relations. Of course, the LMEs have market-based, relatively weak unions, and CMEs more of a corporatist tradition. And then in the educational arena, LMEs are seen as having more focus on general skills, like getting a BA at SOAS, whereas there's more extensive vocational training where you get very particular kinds of skill development that are relevant to certain industries in the CMEs. And even though antitrust is not really a central part of the typology, there are kind of mentions in the footnotes that in general, LMEs should have strong antitrust rules and CMEs have weak antitrust rules. And there's some truth to that, of course. But what we do is I'm sorry. And insofar as this has been discussed, the relationship between antitrust and capitalism, it's generally in the framework of a common story of neoliberalization, right? So it's sort of the idea is that, yes, there used to be a difference, but now that most CMEs have enacted competition laws, they're now, that's actually propelling convergence toward the LME ideal type. So basically, everyone's becoming the US in some way. We're seeing, even in Germany and Sweden, a common neoliberal transformation. And often authors point to the European Union's competition law as directly undermining so-called Rhenish capitalism by giving more emphasis to short-term consumer welfare and private enforcement, and making it more difficult for firms to pursue long-term investments and commercial collaborations that are based on these non-market institutions I just mentioned. But what we do in this paper is not to say that's completely wrong, but to complicate it by using a multidimensional framework for competition law. And here we try to move beyond the idea that there are weak rules and strong rules, and that all antitrust rules do the same thing. And our motivation for doing this is quite influenced by the law and political economy movement that has become increasingly important in the US context. And among these thinkers, Sanjukta Paul, I think, has done the most work on rethinking what competition law does. So she says that in capitalism, we need coordination and competition, right? If you have perfect competition, you aren't able to make investments because you get no profits because everything's driven to zero. But if you have no competition, of course, you get monopoly, and that doesn't work either. So you need to have some kind of balance between competition and coordination. But that can be organized in different ways, right? And so she says that we can think about competition law as falling into two broad dimensions. One is horizontal coordination rules that regulate how firms or workers who lack market power coordinate, often horizontally in the same market. And we can distinguish these from hierarchical coordination rules that regulate the way that dominant companies are able to impose contractual arrangements on suppliers and distributors, as well as the degree to which they're allowed to use exclusionary practices to create barriers to entry, to monopolize or attempt to monopolize a market segment. And that depending on how much a regime emphasizes each kind of coordination rule, we're going to see kind of different sorts of economic structure and economic organization. And so what I've done with Kathleen Thielen for a different paper, but which we use for this one, is to create a topology that develops predictions for the kinds of economic structures and dominant competition model that will develop with different combinations of hierarchical and coordination rules. So in, let's say, the late 19th century German context, when there basically weren't rules, we just let private actors do what they want, we have permissive hierarchical coordination and permissive horizontal coordination, right? And so that tended to lead to cartelistic competition models. To a certain extent, you could stabilize things through horizontal agreements, but you don't deal with the power differential, right? So the largest firm in the cartel basically got to exploit the smaller firms, right? In the US at that time, because they strictly enforced horizontal rules between smaller firms and workers, while not really enforcing any rules against hierarchical coordination, there were no merger rules, there were very limited rules on vertical restraints. That tended to create oligopolistic competition, right? So you wound up with a couple of leading firms in each sector. And so you did have competition, and the market was stabilized, but it was characterized by large corporations. In these two top boxes, we see that these are kind of closer to the CME and LME type. So the CME type, we think, is more likely to be durable and to emerge when you have relatively permissive rules on horizontal coordination between weaker actors, but some rules on economic exploitation by dominant players, right? So we think that is more facilitative of coordinated competition. Whereas the liberal model, we argue, really requires both strong horizontal coordination and strong hierarchical coordination rules. So sort of we need regulators that both limit price fixing and quotas and things like this between competitors, but we also need regulators to proactively ensure that markets are contestable, that barriers to entry don't emerge, et cetera. And then in addition to that, we also have expectations regarding the institutional organization of enforcement, because, of course, the law in books doesn't mean anything unless it actually is enforced. And so our expectation is that non-market coordination will work better where regulators have monopoly or close to a monopoly on enforcement, because that allows them to provide forbearance to kinds of coordination that they think will be beneficial for the economy. Whereas we'll see less non-market coordination where private enforcement is stronger, right? In the US context, for instance, 92% of all antitrust enforcement is private, right? So basically firms sue other firms if they do anything that seems to violate the law. And that does make it more difficult to show forbearance, because even if the government wants to facilitate R&D agreements, those aren't going to be as stable if a competitor can sue 3 firms that are cooperating on R&D. So we developed this model, and I'm just going to grab my phone here, sorry, to make sure I keep the right time. We developed a model that basically is 2 ways. So on the one hand, we see the competition rules as constituting and structuring the kinds of coordination that occur in the 4 arenas I mentioned earlier: industrial relations, corporate finance, interfirm relations, education. But then once we have these different modes of coordination, like let's say a business association or large numbers of corporations, they then become political actors that want to maintain certain arrangements. So that feeds back into the political process through producer group coalitions, electoral coalitions, which then lead to kind of maintaining the competition regime in a certain way, and also leading to changes in response to secular technological change or shifts in the structural nature of capitalism that are, in our view, designed or have the effect of maintaining certain kinds of producer group arrangements. So it's kind of a 2-way process. That's what we theorize. And we try to test both of these theoretical expectations using long-run data. Okay, here's our data. We primarily use the competition law index, which was developed by Anu Bradford and colleagues at the Columbia Law School. It was really a monumental project, took 5 or 6 years to finish, where they coded every single competition law in every single country since the 19th century, according to a complex set of criteria that essentially looks at the stringency of rules across different areas. We combine that with every bit of data we can get on corporatism and welfare states. Most of this only begins in the 1950s, so we can't go back to the 1890s, but we are able to get fairly long-run indicators for union density, stock market capitalization, vocational training, and a lot of other figures that we find to be that we have reason to think are indicators of non-market coordination. To test our political coalition expectation, we used a couple of different sources. So first, we used the Comparative Manifesto Project, which essentially is a database of all party manifestos since the 19th century in OECD countries, as well as a few others. And we use the market regulation item to kind of look to see how often it's mentioned in party manifestos at different moments in time. However, because that is a broader category than we're interested in, it includes competition law, but includes a lot of other things as well, we develop our own competition law dictionary. And then we run that on the full corpus of manifestos from 1890 to 2020. Thankfully, Sebastian speaks Swedish as well as German, so he's able to do a lot of that work in translating the terms we're interested in. But we use mentions of monopoly, fair competition, and consumer welfare as a proxy to see to what extent these concerns are salient in different countries. And then because we were concerned that our text analysis might, that we might be missing something, we also then ran and we read, or we actually had some RAs as well as Sebastian and I did read each of the manifestos and manually coded them, just to make sure that we were understanding what a fair competition meant, in context. And here is the broad, and so here's just the descriptive overview using the competition law data. So here we basically looked at the average competition score across the 3 arenas that I mentioned earlier, divided by CMEs, LMEs, and we put in the EU line just so you can see where the EU stands, as well as other countries outside of CMEs and LMEs. These are mostly developing and emerging economy countries. And as you can see clearly at the beginning of the 20th century, LMEs had stricter rules in both arenas, right? So that mean abuse of dominance is our proxy for hierarchical coordination rules, and the anti-competitive agreements is our proxy for horizontal coordination rules. And this is in part because LMEs tended to be common law countries, and the common law countries had more strict restraint of trade provisions that had developed through private law adjudication. So we see a clear difference there. It starts to converge, though, following World War II, when a lot of continental European countries enact competition laws for the first time, as well as when the EU creates its competition law. But really interestingly, beginning around 1980, we see CME hierarchical rules shoot up and actually kind of stay much more stringent than LME countries. And then when we look at the third graph here on my far right, competition law authority, we do see a clear procedural difference. So this is basically the extent to which private actors can independently enforce the law, as well as how punitive the punishment is for violating the law. And we can see that LMEs really have enacted much more stringent sort of penalties, as well as given private actors more extensive opportunities to independently enforce the law. And if we kind of plot this within the typology I mentioned earlier, we can see that there kind of has been a degree of convergence, right? And that maybe fits with the neoliberal globalization story. But still, CMEs are enacting more strict hierarchical rules, right? And we think that actually might be happening because organized producer groups, organized business interests are demanding this, kind of in part because they're facing all sorts of restraints from above, from Amazon, from Microsoft, from all these big companies that are making it more difficult for them to do what they've long done, and that these demands might be less salient in LME countries. And so in terms of just the movement over time, it's somewhat consistent. And then here's the procedural division. We can see that clearly LMEs have moved more toward this adversarial legal system where there's a lot of private enforcement, and CMEs have not moved to the same extent. Okay, now here's maybe the more systematic analysis. We're interested: is there a systematic relationship not only between kind of where things fall over time, but between objective measures of non-market coordination and the stringency of competition rules across the different dimensions. And here we can see that countries with stricter dominance rules, with stricter rules that regulate hierarchical coordination, they tend to have much more developed corporate systems, right? And this is looking 1950 until 2010. It's not statistically significant, but we do see that there is a negative correlation with horizontal rules. And then there's a clearly negative correlation between the stringency of authority and the development of corporatism. So this, at least initially, is consistent with our theory. When we break down the measures across the different dimensions, it becomes a little bit messier. We still do see a clear relationship, positive correlation between strong anti-dominance rules and higher union coverage, higher wage coordination, and thicker employer density in terms of, that should be employer association density. So sort of how many, to what extent are firms members of employer associations that coordinate various aspects of business across the entire sector. So we see a relationship there, but the stock market indicator really is not consistent. That could be because we've seen the rise of market-based finance really everywhere, right, including in CMEs. And then we actually see a negative relationship with bank deposits as a percent of GDP, and not a clear relationship with vocational training. Interestingly, our horizontal coordination expectation, it doesn't run, when we break it down, it doesn't run in all the directions we expect. My sense is that this could be because the horizontal rules in the European context, at least, tend to be fairly flexible and to allow for significant coordination, particularly in R&D, standard setting, specialization agreements, these kinds of things, and now actually sustainability agreements. So we think that might actually be because these rules tend to be embedded in more discretionary bureaucratic systems rather than adversarial legal systems, but that's something we're still trying to figure out. And then we do see a clear correlation between adversarial legalism and a lower likelihood of having strong unions, wage coordination, and vocational training. In case you're wondering if all of this is simply a legacy of distinct legal systems, there's something to that, particularly in the first 50, 60 years. But then when we start to look at development since the 1950s, it gets a little bit messier. It's not exactly clear if the relationship it can only be explained in these terms. I'll kind of skip that for now. Some reviewers have said, "Oh, isn't this just a story of the EU? Isn't this just the fact that the EU happens to have stronger abusive dominance rules, while the US doesn't?" And here, so we've looked basically at countries that joined the EU and also countries that did not join the EU to see if there's still a difference. So there is maybe an EU convergence story here that could be part of why we see, in particular, the stronger hierarchical coordination rules in many CMEs. You can see clearly here the EU's dominance rules are actually stricter than its horizontal rules. But notably, among countries that haven't joined the EU that are still in our data set, we still do see this difference that we've mentioned earlier. And another thing to think about here is that the EU itself enacts policies that are in part a product of its member state preferences, right? So, a lot of things the EU does actually come from the national level. They're influenced, the EU rules are influenced by business associations, member states. And so we can't necessarily think of the EU as an exogenous force here in this context. The EU itself is being shaped by producer group coalitions. So, but at least here we can see that we can kind of try to decompose the effect of the EU from maybe other effects. When we start to analyze our indicators of political coalitions, it's notable that so here are the results using the party manifesto data. These are sort of the percent of party manifestos that mention competition regulation. And we can see that there has been a higher increase in salience among CME manifestos than in LMEs. And notably in CMEs, it tends to be more cross-partisan, right? So this means you have a more durable kind of coalition in support of stricter hierarchical rules because it's coming from the left and the right. We've seen an upsurge in LMEs as well, but it hasn't become as salient, at least according to this measure. I would say a more accurate measure are the results from our competition law dictionary, because here we really are focused only on competition rules, and we even can disaggregate sort of the different concerns that are motivating them. And here there's an interesting story of among LMEs, we do see an incredible degree of salience in the post-war period, right? But especially in the U.S., antitrust is really a bipartisan project. It's seen as quite important to a free market economy. But then beginning in like the 1970s, 1980s, it completely moves off the radar of political discussion, in part because of the technocratic development of the antitrust enterprise, and also because of the Chicago School Revolution, which leads to basically hierarchical coordination enforcement sort of collapsing, basically. Like we haven't seen any anti-monopoly prosecutions of significance until very recently in the US. The last major one was the 1990s against Microsoft. And so there basically seems to be a story of strict competition enforcement at mid-century that's gradually waned, in part because it's moved off the political radar. While in CMEs, there seems to be quite a different story. It wasn't a particularly prominent part of at least the center right in CMEs at mid-century, but it's increasingly become something that parties discuss. And then for left parties in CMEs, it's been a consistently strong subject of debate in party manifestos. And here I have it broken by country, and you can see that in Germany, which is our ideal typical CME, particularly on the left, we've seen very consistent discussion the problem of dominance and the problem of monopoly and fair competition, and that significantly has gone up on the right, whereas in the UK and the US we've seen a significant decline for at least a number of these terms. And then, interestingly, when we look at the regression analysis of various types of parties and the relationship to mentions in manifestos, it becomes clear that there is a sort of left bias to the to support for competition law. So even though many people in CP see antitrust as kind of a neoliberal tool that enforces competition against other values, that isn't actually what we find in practice in terms of how the issue is discussed. So we tend to see significantly more left parties talking about antitrust, particularly hierarchical coordination and the problem of dominance. And we also clearly see that there is overall more discussion in CMEs, right? So LMEs in general are less likely to discuss the importance of antitrust and competition law. Okay, so this is sort of preliminary work. I mean, we're really trying to better understand the empirical regularity and see if it's consistent with some theoretical expectations that we have. In my book project, I'm doing more of the analysis of mechanisms and kind of how things develop over time in a more granular way. But we think these results do suggest that that this is at least a subject worth thinking about more, that there is systematic variation across CMEs and LMEs in terms of competition regimes, that this is both in terms of substantive rules as well as procedural structure. These differences are correlated with objective measures of non-market coordination, and that does suggest there may be some kind of causal relationship. We can't demonstrate that here, but it's worth investigating, again, at a more granular level. I'm hoping to get more extensive employer association data and kind of see if this really does make a difference. In terms of qualitative interviews I've done with employer associations and business groups, they do tell me they often use the horizontal agreement exceptions that they're allowed to use. So they use the sustainability agreement exception, the specialization exception, et cetera. So that does seem to be important, at least in the calculation of some firms. And that's something I hope we can explore further in the future. One aspect of the finding here that I think is worth exploring with additional tests is whether or not the significant increase in abuse of dominance enforcement is directly tied to producer group concerns, right? In response to the emergence of the platform giants, as well as other trends in concentration. But at least here, we do see that there is a clear upsurge that probably deserves further attention and study. And then finally, I do think that this study points to the value to think more about politics in competition law discussions, right? Right now, the conversation is entirely dominated by economists and lawyers who tend not to think about politics and power. They think this is really always about the technocratic questions they're concerned with. Does it hurt or help consumers? What is the market analysis using our various models and et cetera. But I think actually the political arena does feed into the process. There are lots of different ways you can analyze a technocratic problem. There are many different models, and perhaps the models you wind up using tend to be sort of shaped by politics directly and indirectly. And I think that's something that I would like to see more people consider when they're examining this arena. I'm going to conclude very briefly by thinking a little bit outside of Europe and North America and kind of what the implications of this study might have for scholars who are interested in competition law in South America, Africa, East Asia, and South Asia. So we can see clearly here that in terms of, let's say, the correlation between rules and between the US and the EU, that the EU system is more influential, right? There are more systems in the world that have administrative systems There are more systems in the world that have the abuse of dominance construct used in their law rather than the anti-monopoly one used in the US. And so that does suggest that perhaps we're going to, that perhaps there are similar dynamics in other parts of the world that are worth investigating. When we look specifically at the question of hierarchical coordination rules, it's interesting to see that 80% of jurisdictions globally have established what I would call a structuralist paradigm that limits the power of dominant economic actors. By this, I mean it's an explicit rejection of the Chicago paradigm, and it takes a much more proactive stance against dominance. So, for instance, the South Korea law, they actually came up with a new legal construction called the abuse of a superior dominant position, which has been used to address power inequalities and vertical relationships between conglomerates and suppliers and distributors. So, for instance, Samsung has been a major target. So it's often acting on behalf of the suppliers and distributors to give them a little bit more bargaining rights vis-a-vis Samsung. The US, of course, has called this harmful to efficient bargaining between contracting parties because all parties are equal, according to a kind of Chicago school logic. So to me, that suggests that actually we might see something like a strong hierarchical system emerge in countries beyond Europe. And then when we look at actual enforcement, we can see that there's been a huge upsurge of abuse of dominance investigations and enforcement in major jurisdictions. So like China, Korea, and India have led in investigating platform giants. The Korean Fair Trade Commission has fined Alphabet for abusing its dominant position. The Indian Competition Commission has been investigating Google for monopolizing mobile apps and mobile payment markets. And so this is a space to watch. I think we should all be thinking about, what are the politics of these investigations, and what kind of effect might they have on the organization of capitalism within these markets as well. Okay, thank you very much for your time. I look forward to your questions.
So thank you very much. Let's give a hand of applause to you, Chase, for a very, very interesting paper. Absolutely comprehensive, and it's very, very educational. In fact, the way, even the approach to the paper is in itself interesting. The comprehensive, fundamental way of going into the issue. I have seen a similar approach taken by a presentation by Daron Asemagru at MIT and Robinson at Chicago on some of these issues on political, and very, very insightful. So it's very, very comprehensive. We thank you very much for this insight. There is also a strong motivation on why we should go back to 1800 and then track what has developed around the world to understand competition and the way companies have evolved over time. The evidence so far uncovered is very interesting. And one aspect I agree with you is what you find. You say, I find it very unusual in the way, the exceptional, maybe an irregularity about the way financial stock markets and banks are different from the rest of the world. In a way, that's what I would expect actually personally, because whatever happened in the last 100 years, the financial firms have consistently behaved differently from non-financial firms, because of the nature of the financing. So in a way, that's consistent with the way we say from corporate finance side, that's the way we do our analysis. We separate the financial firms and non-financial firms because of the nature of the way they work. There is also, I like your strong theoretical underpinning, try to explain why you expect your results to be the way they are. Absolutely interesting. It's only that by listening to your presentation, I started to think maybe outside the box, and maybe it's unfair to reflect on some issues which may be sitting outside your current analysis. But one of the things that came to my mind is to think about the context of these ongoing debates, which have featured in the finance literature, started actually dominated by a number of people. It's dominated by Rafael Laporta, is dominated by Francis Lopez Sales, Andrew Schleifer, and Robert Vishny. Okay, their work is about the legal origins, the legal origins of law and competition and all that kind of stuff. And this is the first paper in 1998. Then 10 years later, they did a paper. They summarized the entire work they have done over the 10 years in the Journal of Economic Literature, in which they say it point out the kind of difference global across the world for many years that the legal origins matter. Now, is this work consistent or contradicting or completely different or does not have a year? This is what was back on my mind. I couldn't work out precisely whether you are what is the one now used is disrupting. Whether you are disrupting the momentum of their research, or whether you are again consistent with the way they think the origins matter and the way companies would kind of evolve. Another insight I thought about as I listened to your interesting presentation was think about a international trade theory. You see, there is considered international trade theory, an argument that cuts across all the theories of international trade. That one sure way of disrupting a national monopoly is to open to international competition. And it is cuts across all the theories, whether you take comparative, whichever way, Hexaroin and whatever. So I'm trying to think that maybe because international competition has changed, from, many periods of monopoly, globalization has changed all that aspect. Is that in a way something like the onslaught of globalization and now recently returned to, there is actually scaling way back from globalization? And, how is this reflected in the current work that you are trying to explore? So these are some of the issues that came to my mind as I listened to your interesting presentation. But I guess also I'd like to go ahead and invite our participants. I think if any has posted in the chat or those who are putting up their hands, so that as Chase explained at the start, this is ongoing work. So we can contribute constructively to this going work by, raising some issues, but also appreciating some of the findings that you have so far shared with us. So let me take some comments. I can see a hand up from Professor Yana Frubels, Yana from University of Wales, Bangor, and a close associate of the Center for Global Finance. Yana, it's great to see you, and please go ahead and share with us your comments.
Oh, thank you very much for the lovely lectures, and it's very beneficial by myself. And my interest on, especially my sort of not directly question, but it's something that is that I like to invite the speaker to talk about the relationship, mainly about the corporation and politicians, and then impact on the capitalism or democracy, which is we are thinking about, and choice as well. That is the sort of yes, overall is very nice, very interesting concept. But I felt that there is something missing on that aspect. Maybe I misunderstand overall discussion. Especially we can bring it about corruption, inflation, and then their impact of the capitalism or the democracy and so on. This is both is the system, both is the Anglo-Saxon and continental European approach, and is there. So what is the view? I mean, what is the
Yeah. So would you like me to?
Yeah, please go ahead so we can have a flow discussion. Yeah. Please go ahead.
Okay, great. So maybe I did want to also respond to some of the points that you made, Victor. So maybe I'll start with your question, and then I'll move to those. Okay. So yeah, I mean, we don't really think about capture here or corruption. I mean, I'm sure it exists in both systems. I mean, some people think the lack of anti-monopoly prosecution since the 80s in the US are because of the dominant influence of certain corporate interests. Some people think that the maintenance of more permissive horizontal coordination rules in Europe is also because of the influence of interests. I mean, I would say, yes, that's probably true. But whether or not it's sort of corruption, I mean, what do you mean by that? Do you mean corruption in terms of quid pro quo exchanges at the kind of discretionary enforcement level, like, oh, here's some money, don't investigate my firm? Or do you mean capture in the sense that the rules themselves are actually being shaped in a way that's illegitimate by various interests? So I guess I haven't thought about it that much, but we could, in terms of whether or not there's the first type, the quid pro quo, in the countries that we look at, since I would say that's not the dominant thing that's shaping things, because to a certain extent, they're all in independent regulatory agencies. It is very technocratic. Most judiciaries are independent. So to me, that isn't the primary thing that's happening now. I would say that the deeper kind of capture, where maybe the rules themselves are being shaped in a way that's overly influenced by particular interests, to me, that would be maybe more likely. But certainly, if we go back to the early 20th century, that kind of more informal quid pro quo, micro level corruption, I do think would be important. But we haven't really systematically looked at that. But that's something to think about, because of course that is important in the development of capitalism. Absolutely. So thanks for that question. Okay, so going back to some of these great insights you had, Victor. So yeah, I mean, of course, Laporta et al., that's huge. I mean, they're the ones who've actually they've thought the most about the law and capitalism, right? So I need to actually engage more with that. I'm familiar with the literature. We do use their measures there when I showed the German, French, Scandinavian common law legal systems. Those are their measures or those are their categories for legal systems. And we use those. If I were to, but to answer your question regarding that, I mean, I would say this is complementary in a way, but it's kind of going beyond it. It's not simply that there was a common law system. It's that the common law system was connected to antitrust systems. The initial antitrust systems come out of common law presumptions, and then they get institutionalized and enforced. So I would say that in a sense, they give us a really important beginning origin story of how this, of why we might see this divide. But then I would add to that by saying it doesn't end there. The legal origins are not just unchanging, right? So I mean, the law has shifted and evolved over time, and that's in part because of political input. So I think they kind of tell the first half of the story, and we're trying to complete that story by thinking more about political coalitions. And then in terms of globalization and what effect that may have had on competition law, as well as producer group mobilization, that I think is probably quite important for what we've seen since the 80s. In a way, we could think of the Single European Act, more broadly the liberalization of trade, as creating new pressures on non-market coordination systems, which then lead producer groups to lobby to have some protection, right? So they wind up saying, can you enforce more hierarchical rules against American multinationals that keep moving into our market and then controlling what we can do? So there's definitely an economic patriotism story here. There's definitely a kind of protectionist response story. But because of the nature of policymaking since the 80s, you can't do protection directly, right? But you can find creative ways to use pro-market regulation like antitrust to perhaps give some protection. And in a different project, I have examined whether fines are systematically higher on foreign firms controlling for the size of the violation, the revenue of the company, and these kinds of things. And I find that it's systematically higher. So it's about 200% higher, even within the same cartel. I even have data that allows me to separate fines by different companies in the same cartel. And so I do think there's some kind of economic patriotism story. That doesn't really come into this paper, but I do think it's central to explaining broader developments.
Thank you very much, Chase, and thank you, Yana, for the interesting contribution and the response by Chase. Now, let me go back to the floor. I think Christine was first, and after Christine, I'll ask you, Hamed, to come in. So, Christine, please go ahead.
Yeah, thanks, Victor, and thank you, Chase, for a really interesting paper. And I'm not going to do justice to it. I'd really love to read it in full and then give you more detailed comments. But in terms of my question actually is quite similar to Yena's question, that what you've done is incredible in a way in terms of tracking the history of all of these things. And it's an issue about what is, endogenous and what is exogenous in these systems. And there's a tendency to take the law as exogenous. This is somehow outside the system, because what you're suggesting is actually the law is endogenous in all of this, and you need to integrate politics. And I really like that approach. But I was just thinking, of an example, and I wouldn't call it corruption, but of influence in all of this. So, the Chicago school didn't come out of a vacuum, and the privatization policies in the 1980s in the UK and the US didn't come out of a vacuum. They came out of the Bell Research Laboratories project funded by Bell Telecommunications. And Stiglitz has got that very famous phrase, the theory of contestable markets is well funded but not well founded. And it sort of, it turns, Stern has got a paper in the European Economic Review about this, it turns Keynes's idea that people in authority, by which I think he meant politicians and civil servants, are slaves to economists, completely on its head, that the economists are somehow being influenced in advocating these policies by big business.
Mm-hmm.
And I just wondered, of course, this is a much more, it's kind of there in your story, but whether you could extend what you're doing to endogenize the law in any way. But that's just my thought on where you might take this in the future, really, rather than any kind of question on what you've done so far. But thank you for the paper. It's really thought-provoking, actually, Chase.
Okay, good.
Congratulations.
So, or should I wait? Or
no, please go ahead. Thanks, Christine. Thanks so much.
So this is actually very helpful, because this is what I'm doing in the book, is really trying to look at these episodes and try to explain what really is driving the change over time. So in the U.S. case, a lot of scholars have looked at various sort of influences on the development and dissemination of the Chicago School. So not only the funding of the initial ideas, which of course, as we all know, came out of essentially business owners who were upset about the New Deal, and they started to fund research in the 50s to challenge many of the presumptions that had created the New Deal. And that directly impacted the development of antitrust. I mean, so there was actually an antitrust project that was funded by this foundation in the 1950s that fed into Robert Bork's work later, and other leading thinkers who were quite important in shifting thinking on antitrust in the U.S. context. So we can clearly trace that there. But I guess, and that needs to be part of the story. But I guess as a political scientist, I see influence as something that's inherent to policymaking. So I don't sort of believe in a world where we can ever get rid of influence. So my concern is always not that there is influence, but is there a kind of, let's say, asymmetrical influence? Because I think business associations should be able to influence policy, but the problem is when they're the only ones influencing policy, right? And so that's something to think about. I mean, I don't know if I would say, you know, for instance, there's more structural corruption in the US and less in Europe or something like that, you know, because I just think maybe the nature of the dominant interests are different to a certain extent. And so that is partly why we see sort of much less of a move toward a Chicago-style approach in Europe, because, you know, businesses are organized differently, and so that wouldn't benefit them as much, right? I mean, so, but that's something to think about, actually, is sort of how much should we bring in interest in the story. I mean, part of this is a path dependency story that I do think is where its origins are in some ways partially exogenous. I mean, so if we go back to the Rafael Laporta understanding, you know, if there were just different presumptions in common law systems before the development of industrial capitalism, so sort of by 1860, you know, then those weren't endogenous to industrial capitalism. You know, like they actually were there before. They were influenced by very specific things that were not about industrial capitalism, right? So we see civil law systems develop much more sort of permissive rules toward horizontal agreements, in part because of the Napoleonic reforms, right? That institutionalize a kind of free contractual understanding of private economic relations, right? So it was easier in those systems to say, look, we're just making a private agreement, and we have freedom to do that under the law, right? You know, Germany basically uploads many of those private law rules when it creates the first civil codes in the 1870s. And so in a way that is somewhat exogenous, and that does structure at a very important formative moment the development of capitalism. Once that gets going, there are path dependencies, right? Because you have different kinds of economic organizations that become dominant, and they have interest in maintaining, you know, the arrangements that are established. I mean, in some ways, you could see cartel organizations in Germany and the large corporations that Chandler discusses as functionally equivalent. I mean, they both stabilize the market. They both allow for long-term investment, significant coordination. And so they both work in a way. I mean, in fact, the growth rates of Germany and the US are very similar during this period, right? And they both, I would say, develop quite impressive industrial strength. However, the long-term effect of having a corporate-dominated system and a more kind of associational system is significant. I do think that does then play into union development, et cetera. But certainly, I'm not trying to make an argument that the law is always endogenous. It's more trying to make a sort of historical institutionalist argument that says we can only understand the system we have now by really going back to seeing how it developed over time. But these are really nice insights, and hopefully we can chat more, Christine. Good to see you.
Yeah, thank you.
Thank you very much, Christine, and thank you, Chase, for this discussion on the endogeneity or exogeneity. It's just, I reflect back as you are just explaining this, Christine, and also Chase was answering. I think a paper of mine with a couple of people going back to the 2000, so a little bit dated. We are looking at one question on why has Singapore exceptionally been successful in its financial development strategies. And basically, we're looking at the way the law was changing to suit the financial condition they wanted to develop, so that it can become a financial power in the region. I think there is the truth of in a way indigenizing the law. In the case of Singapore, although initially before those reforms, I know it was exogenous. So maybe there is something very powerful in this argument that we need to bring up, given the experiences of some countries that have become exceptionally successful compared to the rest of the pack.
And what is that paper?
I'll dig up the paper, Chase, and send it to you. It's again, it's very much out of date, but it's a strong way reading this very particular argument of explaining why. And we do actually test for causality and endogeneity and exogeneity using some economic tests. So it might be a little bit relevant. Yeah. I'll dig it up and send it to you.
Great, thank you.
And now we have a hand up, Ahmed, very prolific researcher on the FinTech project at Essex. Ahmed, you are welcome. Please go ahead and yeah.
Right. So thank you very much, Professor Chase. It was a very good discussion, very engaging, and very encouraging insights and very encouraging results as well. I think looking over the summary that you've provided for the entire paper, the conclusions and everything, I think that the data does justice to the overall conclusions that when you have a coordinated market economy, essentially there will be political parties which stress more upon curbing monopolies or having more stricter controls, having more stricter regulations, as opposed to liberal market economies which focus more on consumer welfare. My question is really a very niche question regarding this overall scenario, because I looked over one of the maps that you provided, a map of the world where all the countries were shown with a mark on whether they follow the EU system or the US system. So I found that a couple of countries were essentially marked as both, including Pakistan. That's where I'm from. So that really sparked a sort of curiosity that maybe you can enhance, that you can elaborate on. That if you have an economy where essentially there's neither one end of the spectrum nor the other, where maybe there's a balance between coordinated market and liberal market economies. So how does that influence the competition law, and how does that influence the competition law inspired ambitions of political parties as well?
Yeah, so I should say that I haven't really examined the diffusion of competition law globally in detail, right? I mean, this is other people's research that I was referencing there. So there's a great paper by Bradford and colleagues that looks at this diffusion process, which I can send to you if you write me an email. So I have your email. I'm happy to send that to you. Sure. For some competition systems, the laws are fairly new, and so I wouldn't, make a big claim that these laws have fundamentally structured the organization of capitalism in these countries unless you investigate it first, right? I mean, I think something that's very important with any kind of regulatory, any investigation of regulatory law is to look not only at the law in books, but also the law in action, right? Because, this is something economic sociologists have noted for 40, 50 years. There are processes of institutional isomorphism, right? Where every country in the world starts to do certain things on paper or develop institutions that look like each other, and they may or may not be, actually used, right? So we want to know, like, to what extent is the law enforced in Pakistan? How is it that business organizations and others have responded to it? So we'd really want to investigate that. But if indeed they do have a mix, that might be able to, and they're enforcing it, in the way that they say the law should be enforced, then sure, that could lead to a kind of hybrid. I mean, I think one critique of the varieties of capitalism framework is, why are there only two? I mean, don't we see actually infinite varieties in a way? I mean, every system combines different pieces together. And I think that the strength of the VOC framework is not necessarily in its description of actual economies. It's more as ideal types against which we can judge economies, right? So it's kind of in that old Bavarian sense of no system is fully charismatic, no system is fully rational legal, but understanding the kind of extreme case of the rational legal system and the charismatic system allows us to better analyze what we're looking at. So in that case, we could look at Pakistan and say, okay, does it emphasize hierarchical coordination more than horizontal coordination? What does that mean for the ability of firms to coordinate? What does that mean for the ability of multinationals to come in and move into a market and perhaps dictate various things to suppliers and distributors? So I think I would more see it as, here's a framework you can use, but in order to figure out how to use it, you have to have rich empirical understanding of the case you're interested in.
Yep, that's good.
Great.
Thank you, Ahmed, and thanks, Chase. We have a hand up from Kirian.
Yes, Chase.
Go ahead.
Thanks. Thanks very much for a great paper. Really interesting. I look forward to reading it. I just have a couple of questions. One, if I understand it, you showed an increase in the index of hierarchical antitrust activity in CMEs very sharply towards the end of the period. And just thinking about that, I was wondering whether it might be a reflection of countries where non-national companies are basically the dominant players. So thinking of Germany, and it doesn't have much of a part to play in tech and IT and so on. So that might be a possible contribution to explaining it. But my main question is relates to something I didn't quite understand because you went quite fast. So I didn't quite understand the relationship between competition regime and corporate governance, or the percentage capitalization that you had in your in your first diagram. And I heard you say that that basically that all countries, all regimes were now financialized. Mm-hmm. Which I'm not sure that I fully agree with, because I think if you look at countries like Germany, it's actually quite hard to buy companies. So the market for corporate control seems to me to be still very distinct between CMEs and LMEs. And the market for corporate control is kind of a form of competition. So for me, it was hard to understand which way the relations were going between that and your competition regime. So if you could just say a few words on that, it would be great. Thanks.
Great. Okay, so maybe I'll just to answer. Thank you, Karen. Good to see you, and thanks for those questions. Maybe if I could just share my screen again and maybe go back to that slide. Is that okay?
Yeah, sure. Go ahead. Yeah.
Okay. Okay, so first, here, this is something I didn't actually show, but these are the number of foreign prosecutions over time. And here I'm only looking at cartel data because that's the only data I have comprehensive, for that I have coded for foreign firm status. But since the early 90s, there's been a significant increase in the number of foreign firms sanctioned under antitrust. It used to be that the United States was kind of the global enforcer. I mean, the US has always had this kind of sense of itself that it could enforce its laws anywhere in the world at any time, and cases go back to the 1940s, actually. But since the 90s, actually all countries are doing this, right? And really even relatively small countries that are much weaker than the US in terms of geopolitics are enforcing regulatory rules against U.S. firms, right? So there's definitely some aspect of there's some kind of response to globalization, I think, here. And I don't have the data immediately in front of me, but as I said earlier, similarly sized foreign companies do receive higher penalties systematically, and this is also the finding of Cornelia Voll in her new book, Corporate Crime and Punishment. So I do think that is part of the story. If we were to look at the content of the German manifestos, they almost always are now mentioning big tech, right? And what's interesting about that is that all the parties are talking about it, right? So the Green Party talks about the problem of big tech. Even the Free Democrats, the Liberal Party, is very concerned about big tech, and they're often saying we need to have stricter abuse of dominance enforcement. So that is now at least the motivation in the German manifestos. So I think that fits largely with your intuitions there. Exactly how to draw that out in a way that is, statistically, where we can demonstrate that statistically, we'll have to think about a little more. But I'm fairly convinced that is at least part of the story. Let me just go back to the. Yeah, so one weakness of the paper is that we are not we haven't done a good enough job theorizing the mechanisms, right? I feel some more confident regarding my expectations for the top and the bottom, the inter-industrial relations and inter-firm relations, because I can think of concrete cases where antitrust has been used to undermine coordination in these arenas. So, for instance, right now, workers in the US who are not employees but have independent contract relationships with, let's say, Uber, their attempt to organize has been undermined by antitrust prosecutions, right? So that's a clear example of antitrust law directly being used to undermine worker coordination. In the EU context and many national European countries, those exact same coordination efforts by workers who aren't formally employed but have independent contract status, those have been upheld by courts and by regulators. In fact, there's now a clear exemption in EU competition law for independent contractors trying to improve their bargaining position, right? So there we see a clear mechanism. The education and training and corporate governance one, I don't have as clear a mechanism, right? We include it because, this is in David's, these are, at the center of the theory. We wanted to test it, we have data. So we were more interested in see if there is a relationship. Education and training, to a certain extent, let's say German universities don't really compete, right? US universities, whenever they try to set standards, let's say for financial aid packages together, they get prosecuted for some sort of cartel violation. So, there's an example I could think of. In terms of corporate governance, I think the intuition is that if you have a strict arm's length relationship regime where you're preventing coordination between, let's say, banks in a sector about who they want to invest in, that might somehow undermine the development of the bank-based lending model that we have seen in Germany. That's the intuition. Can I point to specific antitrust cases that are related to that subject? No. And so that's the weakness. We can't be as concrete. It's more of just an intuition. Regarding the trend in financialization, I'm not completely up to date, but my sense was that it was sort of a mixed, it's like a mixed bag story, right? So sort of, yes, we do see the persistence of certain kinds of financial arrangements in particular sectors in Germany, but at the same time, there is maybe a broader tendency toward market-based finance, right? And many of the family-owned firms, are now being bought by private equity companies, et cetera. So, on the financial arena, I do actually somewhat agree with the Baccaro and Howell story that even if Germany has started from a different place, that there is a common trend toward market-based finance, at least. But if you have evidence that that's not the case, I would be very open to that. But that would be my sense of where the literature is now. But again, maybe I'm wrong. Thank you for that question.
Thank you very much, Kirian, and thanks, Chase, for the response. I think quite a number of issues touched on. I was reflecting on the initial discussion from Yana, followed by Christine, and just realized the emergence of a new strand of literature in the corporate finance area about politically connected funds. And quite a number of people, especially, Isaac Wechere and others who are collecting data around the world on distinguishing those firms which would not continue to exist without the political, connections in terms of the CEOs who are politically connected, or the boards and so forth, and whether that would change or the narrative you are presenting, and whether that, of course, has a way of influencing the empirical regularities you have so far uncovered. I must confess that this literature did not actually come to dominate in the corporate finance arena until quite recently. Maybe previously 1 or 2 papers, but now there's quite a huge amount of explosion of work on these political connected firms on both industrial countries and, of course, non-industrial countries.
And how do they define politically connected? Do you remember? Or I can look that up.
Yeah. It's also the corporate governance dimension of they are looking at whether the CEO and the top management, as well as the board, previously held offices in governments, or whether the some of the shareholders actually governments, or whether there is a large government participation, the number of contracts that these firms are executing on behalf of governments, and so forth. Yeah.
Okay.
As a corporate governance type of, just the definition. Basically.
This is why interdisciplinary is so helpful, because I can learn about other literatures that would be useful.
Given the days of multidisciplinary work, expectations that we tick all the boxes and indicate whether the research has this element, I think your work is, top on this and exciting us to think, beyond the confines of our own disciplines. Yeah. I don't see any further comments, feedback, either, unless I'm missing, let me scroll down, unless I'm missing a hand up, also in the chat. But the fact remains that this has been a very, very exciting seminar. Thank you for introducing us to this literature and drawing up interesting aspects and comprehensive coverage way back into the last century of antitrust development, competition policy, varieties. And also, I think one of your last slides is very, very, very convincing when you actually draw a map of the world and show us your entire coverage. This definitely is going to be an impactful paper, and of course an impactful book, which the Center for Global Finance, by the way, will be preparing to launch as soon as you complete the book.
Thank you for that.
and we shall be reminding ourselves about this.
Good incentive to finish the book, so we can do the launch.
Yeah. So I'll give you maybe 1 minute if you have any final word to say, and then I'll close the seminar.
Yeah, I mean, I don't know if I have anything substantive. I mean, just to say thank you for your time, everyone in the online world. These are really helpful questions, and it reminded me of some of the literatures I really need to bring forward more. I mean, they're there, but you kind of don't always. Why is the La Porta work not at the center? And maybe think more about financial versus non-financial firms and the framework. The question of endogeneity of the law, exactly what are we saying about that, and the role of political influence, which that's important to me, but I wasn't exactly bringing that forward. So thank you for all of your thoughts and comments, and I look forward to seeing some of your work next week and in the weeks to follow.
Thank you very much, Chase, and let's give once again a hand of applause to Chase for this. Interesting work, very exciting work, I should say. And Chase actually shared a draft paper with us. And Meng will be coordinating if any of the participants wants to get directly in touch with Chase with further comments or the version of the paper. Please contact Meng, who is here in the audience, to make sure that, and there will be a recording, of course, from this seminar. So once again, Chase and Sebastian, your co-author, thank you so much for sharing with us your work. Let me also take this opportunity to thank all the participants for constructive feedback and for also joining us at this particular seminar. And we look forward to another exciting seminar next week on Wednesday, same time, same place on Zoom. Thank you very much. Thank you indeed.
See you later.
Thank you indeed. Bye.